Hello there, advanced criminal proceduralists. It'll come as no surprise to you that I've been relieved of my command at USF, and I'm trying to make some extra money in Scotland working as a caddy. And so far, it's really going well. But except they make you wear a tie as a caddy, which tends to slow me down a little bit. But in Scotland, if you go to Scotland or Ireland, you know that it rains a lot there. So it's raining today, and that's why I'm in my rain slicker. Unfortunately, it has lightning down the course, and we were on the back nine there, hole number 12, and they called us back. Said we're going to have to wait for the lightning to quit before we can continue the round. So right now I'm in the basement of the clubhouse here in Ireland. There ain't nothing down here in the basement of the Ireland clubhouse. Wait a minute. Scotland, Ireland, yeah, interchangeable. Potato, patata. Anyway, just know that I'm overseas in the basement of a clubhouse in a foreign country. So the purpose of today's time together, well, I'm here. I don't know where you are. I'm hoping that you'll view this at some point. It would break my heart if you didn't. The point of today's time together is to look at the 9. I'm not sure why the graduate assistant only had 9 questions. But, 9, 10, 12, who's to say what's proper? So we're going to go through these 9 questions which talk about the public trial right today, and then I'll assign some additional readings. I said in the quiz, the participation quiz, that most of you took prior to the deadline. I can't say who didn't take it prior to the deadline, but in that participation quiz, I said that we would probably have an assessment now after public trial. I'm backing off of that. I want to talk about the right to confrontation before we have an assessment. So the assessment will include the picking of the jury and the Batson type cases and the Batson analysis. It will include the public trial guarantee, and it will include the right to confrontation. So stay tuned for that next assessment. It's hard because being stuck here in Scotland, I got to remember when the semester ends. So here we go. Are you ready? We're going to look at, now remember we had Waller versus Georgia, the 2 Press Enterprise cases, Globe newspapers for our public trial discussion. The first thing you'll notice, I'm sure, is that there is a conflict here between the First and the Sixth. If the under the Sixth Amendment, the defendant has a right to a public trial. The defendant has it says, remember the Sixth says that in all criminal prosecutions, the defendant has the right to blah blah blah, a public trial. So some of these cases, they spend time on, well, does the public trial guarantee cover a suppression hearing? Does the public trial guarantee cover the voir dire? Does the public trial guarantee cover a preliminary hearing? And I always think, well, on the preliminary hearing side, I can see where there might be a question because, hold on a second, from a defendant standpoint, the public trial guarantee, from a Sixth Amendment standpoint, the public trial guarantee would not include a preliminary hearing, because a preliminary hearing is not. Now I know that you're talking about Mr. Diaz there in I can't remember whoever had his preliminary hearing, and the press wanted to get to the preliminary hearing. That's a case about the First Amendment right of access to a court. It has nothing to do about stages of the prosecution. It has to do with the First Amendment right to access the court. So under the Sixth Amendment, the Sixth Amendment doesn't allow the defendant a right to a public. This preliminary hearing doesn't fit into the public trial stage, because there's been no criminal prosecution commenced. Until that information is filed, or an indictment is filed, or an arraignment has occurred, there is no commencement of a criminal prosecution. So from a Sixth Amendment standpoint, the preliminary hearing is not included in the public trial guarantee. From a First Amendment standpoint, the preliminary hearing is included in the access to courts guarantee of the First Amendment and the right of the press under the First Amendment. The Supreme Court always says, or it has always said, that a responsible press is the handmaiden of the judicial branch, is the handmaiden. A responsible press is the handmaiden of effective judicial administration. So the press is an integral part of the judicial system in that the press shows the public the workings of the criminal justice system such that the public can determine for itself the fairness of the system. And that would open up the public to think about things that might make the system more fair, or places in the system where there are holes, things like that. So the press has a pretty broad right to attend any sort of court proceeding. And notice that the Supreme Court says that trials have historically been open. There is a presumption, a legal presumption, that a trial should be open. Which means if you have a legal presumption that a trial should be open, that means that the burden is on the person seeking closure to overcome the presumption. The burden is, so the presumption is that the trial is open. The trial is open. And it's up to the person who seeks closure to prove that closure is appropriate. And the Supreme Court, because we're talking about fundamental rights here, we're talking about fundamental rights, the Supreme Court uses the strict scrutiny standard to determine whether a closure is appropriate. And you remember the strict scrutiny standard. You've heard it a lot if you're in criminal law in the family, but the strict scrutiny standard says that the person seeking closure has to identify a compelling interest that justifies the closure, and has to show that the means of closure are narrowly tailored to achieve that interest. They're narrowly tailored to achieve that interest. So if a defendant wants to close his trial, defendant says, "Your Honor, I waive my right to a public trial," the court doesn't automatically close the trial. The First Amendment allows the press to ask the court to keep it open over the defendant's objection. So it's not just up to the defendant whether that trial is open or not. So you have to make sure in these public trial cases that who is actually seeking closure and who is on the other side of that. So in every case but Waller is the only Sixth Amendment case. The other cases are First Amendment cases where the press is seeking access. So it's an interesting area of the Sixth Amendment. Now, the Sixth Amendment, when you're talking about does the public trial guarantee extend to voir dire? Well, of course it does, because that's after the commencement of a criminal prosecution. Does it extend to a suppression hearing? Yes, it does. A suppression hearing occurs only after arraignment or indictment. So, from a Sixth Amendment standpoint, it's easier to see what proceedings are considered to be part of the public trial or part of the trial. So we work from these presumptions that in the First Amendment, the press has a right to attend any court hearing. The courts are historically open. If a judge wants to close it or the prosecutor wants to close it, the prosecutor has to prove that that the government has a compelling interest in the closure, and that the means of the closure, the strictness of the closure, is narrowly tailored to achieve that interest. Okay, so let's go to the questions. Here we are. We commence our number one, the public has an absolute constitutional right to attend a criminal trial. That, of course, is false. There are no absolute rights in the Constitution. When I say absolute, I mean that the right cannot be limited by the government, and that's not true. That right can be limited by the government as long as the government passes the strict scrutiny test. Number 2, yes, the stage of voir dire, the stage of voir dire is covered by the public trial guarantee. Of course it is. Voir dire occurs. Voir dire, for number 1, is part of the trial. So that fits within the language of the Sixth Amendment. But the voir dire also obviously occurs after the commencement of the criminal prosecution. In determining 3 is false, we don't use rational basis. Rational basis is a very low hurdle for the government to get over. Most of the time, the government is able to show that there's a rational basis for its actions. And the rational basis test is used only when there's no constitutional, when there's no fundamental constitutional right involved. Number 4, the moot issue. The moot issue. I think that saying is interesting. An allegedly moot issue if the issue is capable of repetition yet evading review. That's true. That's true. So, under Article 3 of the Constitution, the judicial article, it details that the judicial branch has jurisdiction only over cases and controversies. Cases and controversies. So if an issue is moot, which means that, for example, in the voir dire case, press 1 of the voir dire, the transcript of the voir dire, they were, by the time their issue got to the U.S. Supreme Court, that criminal case was done. That criminal case was done. So then it was no longer a live controversy at that point. No longer a live controversy. But the court said, you know, this issue is going to keep coming back to us. We better decide it. It's capable of repetition yet evading review. Just like in Roe versus Wade, when Jane Roe wanted the abortion and the law prevented it. By the time her case got to the U.S. Supreme Court, she had had the baby. So a person could argue, well, that the issue's moot then. Her claim was to an abortion. That claim is passed now with the birth of the child. Therefore, the issue is moot. No, the issue is capable of repetition yet evading review. Number 5. Ooh, now you got to watch out. You got to watch out here. It says, if it is per se unconstitutional for a government to have a mandatory closure rule. That is true. Remember, per se, by the fact that. So, by itself. If you have a mandatory closure rule where the government says we require in all child sex abuse cases that the courtroom be closed, that is on its face, by itself, unconstitutional, because you're not showing that the means of closure are narrowly tailored. This blanket mandatory closure order is by itself unconstitutional. By itself unconstitutional. The only way a closure order is constitutional is if the government presents a compelling interest for the closure and the closure is narrowly tailored to achieve that interest. Number 6. So going back to number 5, the partial moral of that story is make sure you understand all the language in the question. So it is per se unconstitutional. Per se means by itself. A mandatory closure order by itself is unconstitutional. 6. This is true. And the court recognized this, I believe, in Globe newspapers, that safeguarding the physical and psychological well-being of a minor is a compelling interest. Most of these cases, at least since Globe newspapers and things, they have arisen to protect a child witness in a sexual abuse prosecution or a rape prosecution. You have, in those types of cases, if the court orders the proceeding closed to the public for everybody, that's going to be unconstitutional. But if the court orders that during the child's testimony only the defendant's lawyer, prosecution, and the child's parents can be present and one member of the press, that might be okay. But if the court kicks out the press even, that's probably not going to be okay. So I want you to remember that in a child sex abuse case, the U.S. Supreme Court has recognized that protecting the physical and psychological well-being of that child is a compelling interest. But it's up to the government then to narrowly tailor its request for closure. Who are we going to close out? Who are we going to keep out of the courtroom? And how is keeping that person out of the courtroom, how does that advance the interest of protecting the child? Now, we'll get into, when we talk about the confrontation clause, we'll get into whether the defendant, as a confrontation matter, can be separated from the child witness during that testimony. So you've got two issues there. You've got a closure issue, and you've got a potentially a confrontation issue. Now the judge, I was going to say, and it would have been wrong, unfortunately, which is why I'm now a caddy in this old basement of a golf course in Scotland or Ireland. Can't keep them straight. I was going to say that, I forget what I was going to say now because I got all mixed up where I am. This hibernation stuff is playing tricks on my brain. It's like when I was in solitary confinement. Now I've really lost it. Let's see, I'm going to go back to the question. We were talking about a minor, blah, blah, blah. Oh, if it's a closure order, a judge isn't going to, I know what I was going to say. I was going to say that it's always unconstitutional for a judge to separate physically a defendant from a witness under the confrontation clause. That's not true. There are times when that could work, and that's not necessarily a closure order. A judge can keep a trial open to the public, but split up the defendant and the child witness for confrontation clause purposes. We'll talk about confrontation. Really cool. Confrontation is really cool. Okay, so we're talking about the physical and psychological well-being of a minor. Vitally important. Number 7, in the Globe newspapers case, that's false. The defendant didn't object to closure. If you've got, if the prosecution wants to close, and the defendant objects to closure, the press will probably be a party to that action. Prosecution wants to close, defendant says, no, I want it open. It's likely going to be open. Because you've got the defendant who has a right to its openness, you've got the press who has a right to its openness. It's probably going to be open. Second press enterprise upheld the First Amendment right of access to trials. Even that's true on 8. And that's true on 9. Waller is the only one that deals with the Sixth Amendment as applied to the states through the 14th. So those are the questions, the discussion of the public trial questions and cases. The main things to remember, the main objectives to remember from those cases is there is both a First and a Sixth Amendment protection to a public court proceeding. The Sixth Amendment protection applies only to the public nature of the trial, which includes the voir dire and the suppression hearing. The First Amendment, however, is much broader than that for the press and the public. That applies to all court proceedings. Courts are historically open. The only part of the court system that is historically closed is the grand jury. And the Supreme Court sticks by the private nature of the grand jury. But they do protect, the Supreme Court protects the openness of courts. So Sixth Amendment is more narrow, First Amendment is more broad. Most of the time in these closure cases, it's a First Amendment issue. It's a First Amendment issue. But it's also a defendant's issue. When you have a defendant, if you have the defendant and the press at odds, the press's right is stronger. But it's not, remember, it's not an all or nothing proposition on the closure. It's up to the party seeking closure, and this is the second most important thing to remember. The first thing is the Sixth Amendment protection is more narrow than the First Amendment. The second thing to remember is that the strict scrutiny test will be used by the courts in determining whether closure is appropriate, and that can be a complete closure or a partial closure. And remember, it's up to the party seeking closure to show that there's a compelling interest justifying the closure, and that the means of closure, the means the party is suggesting for closure, are narrowly tailored to achieve that interest, are no more than necessary to achieve that interest. So those are the two most important things to remember out of those public trial cases. Most of the time it's going to be the press complaining about lack of access, rather than the defendant complaining that the judge closed his trial. Okay, so that is those questions I'm posting, and I'll send you an email. I'm posting a couple of cases to get us started on the Confrontation Clause, and we'll go from there. I hope you are doing well. Please let me know if you have any questions. Thank you. Goodbye.